We're going to get started in a few minutes. Well, all right, everybody. We are about to get started. Sorry for the delay. But I will blame the folks in the room. But if everybody is on, can you just kind of give me a thumbs up that hear me and we're good to go? All right. I see somebody say they can hear me. Well, good afternoon, everybody. Hey, Niles. Yeah. Good afternoon, everybody. My name is Tavares Walker. Obviously, most of you know that. Some of you may not know that I've. And my good friend the Cravens, I see they're on too. Let me stop before it becomes a party. But I am not a full-time Southern employee. I'm only saying that because people still think that I work here, but I still teach here. But in my full-time capacity, I always tell people most days I have the pleasure of serving as the assistant secretary, but few days I have the disdain of serving. But it's fun. It's something new to try. And I throw the plug in there because if you know any folks who are looking to upskill themselves, obtain a trade or some other credentials that want to get back in the workforce or create themselves a better sustainable living, come see my folks in the Office of Workforce Development. We have some money to spend on those things. So the presentation, we're going to talk about ethical considerations and COVID-19, the global pandemic. And I will tell you, in my research and studying of this, the courts, to me, in my opinion, this is my humble opinion, have been reluctant to issue concrete rules. They've given guidance. They've given some talking points. I looked at the Bar Association website. They've had over 30 webinars since this started, but there's nothing concrete that say you should and you shouldn't do this, or you have to do this or you have to do that. They've given you all of these things to consider, which I think are best practices, but how does the rules come into play? So I will attempt to talk about some of those best practices, as well as weave in where I think the rules of professional conduct could come into play based on our actions that we have, that we're engaged in. Why is it not moving? Well, anyway, I talked a little bit about that. This just a little bit about who I am. You know, I always like to put on the screen who I am and what I've done. I had a spirited conversation about my previous work here at the university. I am a proud veteran of the armed forces. I see my buddy, the Cravens, is on. We spent a lot of time together in the Judge Advocate General's Corps for the Louisiana National Guard. I still serve on the Ethics Advisory Committee for the LSBA, and I'm a Bar Governors Committee member. So the first thing, you know, I kind of play on words and kind of funny and not funny, but COVID and ethics, let's stay safe, right? You know, everybody sign off on emails, stay safe, stay healthy. This is in that same realm of staying safe. How do you stay safe professionally? How do you not get yourself into an ethical trap, if you will, with practicing remotely or practicing electronically and all of those things that we've been allowed to do, particularly with signatures. I'll always tell people, I never thought Louisiana would ever get to the point where you can virtually notarize something or virtually sign something. You know, we just started virtually filing things, you know. So I think, you know, this pandemic has made us move by leaps and bounds where we just simply said we were not going to do that. And so I find that interesting in and of itself. So some common issues to consider, the practice remotely, right? What does that mean to the practice of law? And when you say practice remotely, for instance, for the law school, students are attending law school in a Baton Rouge law school, but we have a whole class of students have never stepped foot in the state of Louisiana. Well, the bar is struggling to deal with this idea of practicing remotely, because if you went back home or you went somewhere else, well, now you're practicing law in a jurisdiction that you're not licensed. And the bars, all the bars across the country are struggling to deal with what does the word practice in another jurisdiction mean. Just because you pick up a phone or type something in Florida doesn't really mean that you're practicing law in Florida. And so that's a big ethical concern for lawyers. And as the slides say, many states have adopted rules of professional conduct, making it unauthorized practice of law for a duly licensed practice to practice remotely from a jurisdiction where he or she is not admitted for longer than a temporary period, main word temporary period, or without meeting several stringent requirements. Now, obviously, that's the ABA's statement. Louisiana has not adopted such rule, which I think is interesting because we like to rule ourselves to death. We like to create a rule for everything. But nonetheless, the rule that's implicated by this notion of not practicing a jurisdiction that you're not licensed is Rule 5.5 of the ABA model rules, and that has been codified and extended in Louisiana Rules of Professional Misconduct 5.5. And it says ethical obligations on the Louisiana Rules of Professional Conduct to provide competent representation to protect the interests of our clients at the termination legal representation by the lawyer to the extent reasonably practical, and the duty to act with reasonable promptness and diligence. And as we go on in the presentation, you're going to see what I mean by that, where there are really no hard and fast rules on how to do this, but they're really looking at your diligence, your reasonableness, your competency, your eye to protecting the client's interests. And it appears to me that Louisiana is more concerned with those things than necessarily where you're actually doing it, actually practicing law. And I'm not going to bore you with I just put it up there because I understand the PowerPoints will be shared with you guys. But as you can see, ABA model rule is a little shorter, or extensively shorter than what Louisiana we have. Again, we like to codify ourselves to death. So you'll be able to review the rule, and it goes through all of these things about practicing law when you're not supposed to be practicing law. What do they consider the unauthorized practice of law? How do you respond to the unauthorized practice of law, and your ethical obligations when you discover or happen upon the unauthorized practice of law? And so I'm not going to bore you with going over all these rules in the essence of time, but nonetheless, I put them out there for you. So we're going to skip those. So these are the five things that I have found and been able to put together based on what the Louisiana State Bar Association and the American Bar Association has put together. And these are the 5 points that I kind of want to hit on. And as you can see, I attached the Louisiana Rules of Professional Conduct that deals with each of those issues. And the first one talks about communication. And that rule 1.4a say you have to keep a client reasonably informed about the status of the matters and comply promptly with reasonable requests for information. And obviously, with courts suspending operations and lawyers being forced to work from home, this can be daunting. But guess what? It's required. And you have to do it, and you have to do it based on 1.4a. And my research indicates it's not enough just to say everything is suspended because of COVID. You have to continue to move your client's cases forward in a manner that's reasonable. Your diligence. A lawyer has a fundamental obligation to represent a client competently and diligently. That includes pursuing a matter on behalf of the client despite opposition, obstruction, or personal inconvenience to the lawyer. Hone in on the personal inconvenience to the lawyer. Just because your office is closed, just because you don't have staff, that does not mean that your client's needs go undone. And again, with businesses temporarily closed and courts suspending operations or altering operations, that can become very, very difficult to manage. Competence, changing times mean new opportunities. Not only are attorneys being asked to work in new environments, but the clients are going to ask new questions that you should be prepared to answer, such as we were talking about the governor's orders, and I took everything related to the governor's orders out of the PowerPoint slide because I wasn't competent to talk about them because they've changed so much. And the governor recently issued a new order about 8 or 10 days ago that I haven't had a chance to review. So the governor emergency proclamations allow for a lot of electronic transactions. It allowed for the notary acts to be done via telephone or video capabilities. The bar and the courts are expecting you to be able to understand those things, be aware of those rules, and employ some of those things to further your client's interests. And so the competency piece extends to all of those electronic measures and those emergency orders, particularly for moving cases forward. Now, there's some very, very important things in those articles, like the suspension of prescription and those things that I think all lawyers should pay attention to, because it appears to benefit the client by the suspension of some of those filing rules and filing deadlines. But more particularly, you need to pay attention to those things, those electronic means that's been allowed based on the governor's orders. And you can visit gov.la.gov to look at all the emergency proclamations. And in the proclamation, it specifically lists out and delineate those things that have been suspended or those things that are allowed by the governor's proclamation. Now, I will caution you to pay very, very close attention, because those things do change every 30 days or so. So just because something was there last month doesn't mean it's going to be there next month. And then at some point, the emergency proclamations will go away completely, because right now we're still under the declaration of emergency. And once that declaration goes away, all of those orders go away, and the governor's powers to suspend things go away as well. Confidentiality is a big one, right? We're using technology. We have to ensure all the means of technology that we're using, particularly when we're exchanging client information, that we are operating in a secure environment, because those rules of confidentiality applies even with video conferencing, share files, emails, and alike. And obviously that's under Rule 1.6. And the next one, the bottom one, is Supervision Rule 5.3b, with lawyers being out of the office. You're not there with your staff physically. There's always something that can fall through the cracks where that non-lawyer can be perceived to be practicing law. That obligation extends remotely, even though that office is not a physical office, that it's a virtual office. That I want to point out that supervision piece I have seen being popped up because folks are communicating more with your support staff. And there's always that fine line you have to, on a normal basis, you have to deal with, but be very careful in a remote or electronic environment that a non-lawyer is not practicing law. And this is some tips that I put up there talking about maintaining clear and regular communication with client. Include how do you communicate, engage with contact, provide the client with the best way to contact you, the mail, phone, text, video calls, whatever method works best for you, but just make sure it's documented, right? Make sure if your office is closed that they have a way that they can reach out and touch you. I mean, that sounds like AT&T, but yeah. Providing them with status updates about their cases. Make sure clients understand to the extent in which the courts are operating, right? I always say overshare, because then it kind of fend off the complaints, because they understand where you are and what you're dealing with. Even in the midst of pandemics, clients still believe that their cases is the most important to them in the world, and that's true. And if you don't know the answer for the clients, don't be afraid to admit it. Don't make something up. Just say, I'll get back to you. But, what I found, what I think is important, just refer the clients to the local court orders or the Supreme Court. That might sound mundane, but if the client can see in writing that the court is closed or the court is not taking people in person and people are only taking folks via Zoom, then I think if the client sees it from the court, they may have a better understanding of where it is. This is the one that the last two we don't talk about a lot, and of a succession plan and power of attorney, right? All of us can get sick. All of us are susceptible to getting sick, but you still have that ethical obligation to continue your practice of law. So one of the tips that the ABA put out is that you have a succession plan. They call it a substitute lawyer, a backup lawyer that can pick your cases up and at least maintain them until you get back well enough to continue your practice. But you have that ethical obligation. And, the ABA suggests to ensure that you fulfill the ethical obligation, that you have some kind of succession plan in place. In regards to your clients, I never thought you would have to think about that right now, but when you take on a client, maybe the client needs to give power of attorney to somebody to talk to you, right? Because they end up on a ventilator or something like that. What do? So it's some of those things that you have to talk to your client about that ordinarily you come to me, I just want a divorce. Well, we got, a court proceedings that go on. What if you get sick? Who's going to stand in your place? Who can tell me what direction I need to continue going in? So the ABA and the LSBA suggest that on the front end in engagement with a client that you suggest to them about maybe giving somebody a power of attorney specifically to further this piece of litigation for you so that you can always further that client's interest, even if that client is incapacitated. That's my words, hope for the best and plan for the worst. The ABA has stated that lawyers are strongly encouraged to prepare a comprehensive succession plan for attorneys in large law firms. Obviously, somebody can typically step in and do that. But for those solo practitioner or small firms, I kind of talked about that previously. The first thing to do is find somebody to stand in your shoes. Again, you never thought you had to do that. Like, you think you're fine, but just find somebody to who can manage your operation temporarily for you while you are potentially sick or exposed or quarantining of all those things. That is the biggest thing that I deal with every Monday at work, because I got to figure out all of these folks that went home to spend time with their family on the weekend, and then they all come in with all of these, what we call the FFCRA forms. That's the medical leave form that I've been exposed. My child has been exposed. The daycare is closed. And it's like, oh God, you find yourself contact tracing. Yeah. Yeah.
They had no succession plan, but what do you do? I mean, I don't know, but what do you do in that instance where your client is really good? I'm ready. This is going on the floor. Community property.
What I would do, and this is me, I would interface with the court, right? Because you got to think about covering yourself. Yeah. And you want to be respectful to that lawyer and that lawyer's condition, but I would interface with the court. I would file something that would bring the matter before the court and let the court decide what they're going to do. Because then it relieves you, right? Because you've done all your diligence and reasonableness. And you can say, look, the court has stayed these proceedings based on this. Yeah. Here's the order.
And I was looking for maybe something. I literally searched.
Because I would think if you do nothing, I think you expose yourself.
The thing about it, them bank work, they're coming back in part time. I know good way you also believe. And I don't want to be, I understand when you're sick, but. It's community property, but if you do, it's my client. You still got to go through. Yeah,
still have to. I'm reading here. It says you still have the obligation to move the case forward, but need your client to move your case.
Well, and that's where you get stuck, and that's why what I'm suggesting is you think about all these things on the front end. Right. And on thinking about it on the front end, the ABA and Louisiana has said that you might need to discuss a power of attorney with your client so that they have a backup plan in place.
So I'm just going to write it myself. But I know you've been sick, and I hope you have my client. Please let me know, otherwise I'll
status stuff would be the thing that was helpful for lawyers.
Yeah. And so this slide talks just about what you're talking about. whatever your general obligation. I mean, generally you got to keep the client reasonably informed on the status of the matter. The fact that the client may have COVID does not lessen your duty to keep that client informed. But again, one of the guiding documents, the guiding things was talk to that client in advance. Look, we operating in this environment, both of us or one of us could get sick. What do you want me to do if, and get those things in writing. And because you will get to a point in your case that you can do certain things, but without that client's participation, you will get stuck. And what I'm suggesting is the bar and the courts are saying that just because that client is sick, don't lessen your obligation to be diligent, reasonable, competent, and all those things, and move that case and protect that case in the best interest of the client. What happens if the client battle with COVID worsen? We talked about that. The ABA model rules suggest that a lawyer must remember that the fact that a client suffers a disability does not diminish the lawyer's obligation to treat the client with attention and respect. That's a copy and paste out of the ABA rules.
So you can get your money. Or just finish the case and put it in the registry.
Well, I don't know all the rules, but it sounds like to me that you got a conflict now that will force your withdrawal. And and because now, and read you the succession guru, I would think it's her claim by way of.
Well, you got two things. She's a surviving spouse, but he said something about children.
Well, what I'm saying is somebody's claim now.
The succession representative needs to be substituted.
Right.
But she's talking about a separate claim other than the one you were hired for.
Well, it's all involved. The succession representative.
They can't, yeah.
But I mean, but what he's saying is you already have a lawsuit already filed.
Yeah, I filed it.
Yeah,
And they
so
gave me 5,000 to settle with her.
she still would, she could be the succession representative, so basically amending the petition, letting the court know that he's now
I did that.
and she's stepping in as a succession representative. After that, then that's a whole nother thing, but that's conflict. That's not opening up. You're amending the petition.
Just to put somebody in his shoes.
Yeah, which would be the succession representative.
But
Yeah.
if
And then you could.
he was ill before he died and she had the power of attorney.
That don't even exist.
Step in because a dead person can't carry on the lawsuit. Somebody has to put his request.
She has an interest. She's not named, but she has an interest in the estate. Now, before she can get any proceeds or anything like that, the succession, she's gonna have to be named. Yeah.
But then, like you said, you send that letter, put the money in the registry of the court.
Yeah, it's conflict.
It's conflict that you don't want to do.
Right.
You just put it in the registry and then she got to open up the suit anyway.
She hasn't signed the release, now she won't sign it.
That's not your problem.
Yeah, that ain't your problem.
That's your problem.
Yeah.
So let's come, like you said, keep playing.
Yeah.
See why, I'm thinking, y'all just don't know how to.
Okay.
Y'all got them.
So we're gonna move on to diligence, and this is just some recommended best practices. Stay informed. Check the Louisiana Bar Association has numerous resources. that keep lawyers. Somebody's talking. Hold up. Keep up with all the administrative orders, executive orders, local court orders, and the LSB has a frequent asked question page. As I mentioned to the group before we got started, there's over 30 webinars that they've created. All have supporting documents with best practices and the best use of technology. The use of technology, in my opinion, I think is going to hang a lot of folks up. You know, I always giggle when I see in the paper that folks have hijacked court proceedings, Zooms, and and lawyers' inability to use the Zoom properly. My research indicates that the Supreme Court holds you to the standard that you need to learn how to use these things, and that it is with us for the time being and the foreseeable future, and that a part of being diligent and competent and reasonable, that you have to learn how to utilize all of these technologies, Zoom, Meet, Teams, all of those things, which, by the way, y'all, I absolutely hate all those things right now. It's like folks have Team and Zoom this thing to death. One of my work colleagues, her office is 3 doors down from mine, and she's like, I'll send you a meeting invite. I was like, no, come walk down the hallway and talk to me. And take advantage of video conferencing, remote notarization, email, e-filings where available. I say that again because the Supreme Court expects you to utilize these things to further your client's interest. You can't just say, well, we can't meet in person. I can't do anything. What a governor's proclamation and executive orders allows us to do a whole bunch of things that we never imagined that we could do electronic. And quite frankly, I'm not comfortable doing. I can't imagine notarizing something remotely for somebody, but it's allowed. It is allowed under certain circumstances. I never thought that they would let government bodies meet virtually. It is allowed that government bodies can meet virtually. E-filing was kind of rolling out a little bit, but now it's been fast. Just about every jurisdiction now has some version of e-filing, and not fax filing, e-filing, where you can e-file and they charge it. That's communication with clients is imperative so that the client are aware of the status of their matter, any restrictions on a lawyer's ability to continue representation, and restrictions imposed by the court. Again, this is mundane and might be overly burdensome, but when a court issues an order, it limits the practice of law, such as they often do in East Baton Rouge, with a court closed. You need to let your client know that, like, hey, the court is going to be closed for a week. Our judge is going to be off for a week. Somebody in the court, that section have to quarantine, so they're not working. Let your client know that, right? Because what's going to happen is all the court days going to get reset, and you're going to have to explain to your client a month later what you should have told them when you first found out. And it creates less controversy. It upholds your ethical standard if you just let them know, like, hey, we got this notice that section K or whatever court is going to be closed. That's our court. I just want to let you know there's a possibility that your case might get bumped or moved to another date, and here's why. Because they always think when something is continued, either one or both of the lawyers decided to do it because they don't want to go to court, even though you're in cahoots with each other, right? I mean, and that's their natural inclination. I don't care. Yeah, I don't know it doesn't matter what the clients are, what level of representation, they all believe that the lawyers are in cahoots together. And self-assessment, right? And I just put that up there. Take care of yourself, be honest with yourself. Your limitations during the crisis, you have family limitations, children limitations, all those things are personal in nature, but it affects your ethical obligation to practice law. Because if you have to stay at home with a child who's being quarantined, and at one point children was being quarantined every other day, that's an ethical obligation that you have to deal with your client. Competence, both substantive competence and technical competence. We kind of talked about this already, about the use of all of the technology and all of those things that was thrust upon us so quickly. Many clients' legal needs will change during and after the pandemic. More clients will request estate plans. They will try to understand changes to federal and state benefits. I threw that part in there because I'm in charge of a large organization that has ran the largest social service program in the history of modern man, and the rules constantly change in the history of modern man. I'm talking about unemployment. My agency doled out some 12 billion with a B dollars that a whole bunch of folks gonna have some issues with down the road. So just make sure as lawyers that you understand all of those rules that come along with, and clients are gonna come to you asking, what does this mean? What does that mean? Don't call me because I don't know. I just run the place. They're gonna want to know how unemployment affects pending family law cases. They want to take extraordinary steps to keep their businesses alive, i.e. PPP loans, and so many more questions that you may not expect. I would just, as a word of caution, no legal advice here, just an old lonely state official, be careful with that stuff because it's coming. And they're going to review everything that everybody, the claimants, the lawyers, anybody who was, involved in that process. If you decide to provide answers, make sure you do competently. Research and learning the answers to novel questions can also help you not be bored at home if you're working remotely. Resources available to help you. All the ABA sections and the law LSBA sections have focused on access in a remote environment. Technical competency, we talked about all of those modes of communication and processes that we are now using. Make sure you understand when you start using electronic ways to exchange files and things like that, that you understand what a server is versus a cloud, which I had to have a crash course in last week because I didn't understand all of that because I'm not that technically savvy. I mean, I know I got a cloud on my phone, but, i.e. most of you should know that most things are no longer saved in server boxes in a room, right? They're backed up to a cloud that might be in somewhere in Never Never Land, where you have to understand what all of those things is and what does it mean and what's its security, because again, that ethical obligation, that rules of professional conduct with confidentiality even extends to those cloud-based programs that we all use and that we might not realize that we're using. And particularly everything we do on Zoom and Teams is all saved to the cloud. I don't know if everybody know that, but there's a little cloud you see up there blinking right here. So even this presentation is being saved to the cloud. No, it's being recorded. So that's why it's being saved to the cloud. So it's not being saved. It's not being saved on a law school server or a law school computer. It's being saved in a cloud. Right. Yes, go away. And so I kind of got ahead of myself about the confidentiality rules. A lawyer has an ethical obligation to protect confidential client information, exercise a reasonable care to prevent disclosure of confidential information. The ABA rules say a lawyer must formulate, adopt, and follow policies and procedures appropriate to the lawyer's field of practice regarding the use of transmission and storage of client information. This is particularly important when working remotely and using all of those electronic resources that we've been talking about. You may want to consider, again, this is an ABA suggestion. Cybersecurity has changed over time and with the advancement of technology. So you should periodically reassess your policies and procedures, and particularly which programs that you're using to store files and communicate and share your clients' confidential information. And that's just to make sure that the technology is keeping up with what's going on in the world, because previously we can buy software and didn't have to worry about updates and changes and new formatting and things like that. But the ABA suggests that whatever file sharing or programs or software you use in your office, that you see if that has some kind of periodic check that kind of upgrades the security features. Supervision, and this is a part that talks about lawyers supervising non-lawyers. Even though lawyers may not be working in a traditional office setting, the duty to supervise still remain in effect, and that's per the rules of professional conduct. Any lawyer having direct supervision authority over a non-lawyer must ensure that that non-lawyer's conduct is compatible with the professional obligation of the lawyer. A lawyer should give non-lawyers personal assistance, appropriate instruction, and supervision concerning the ethical aspect of their employees, particularly the obligation not to disclose information related to representation, which, if I'm being honest, you see so much on Facebook and social media. It's like, did your client really say you can say that or post that? Or, and it's like you always ask yourself that, like, you sharing a settlement check on social media. Did your client tell you they can do that? And did your client tell you to do it, but have you then now created an advertisement which is regulated by the Bar Association? Again, that's all the ethical concerns in my head be going on.
I said that. If you have a Facebook page, advertising yourself as a lawyer, Joe Blow, attorney at law, Facebook page. Is that something that is scrutinized by the because you said you were a lawyer?
The answer to that, I would say, is no. But I do think if you start posting things about the practice of law, about your practice of law, I think that's when you cross the line. And I think that's when you get into whether or not that is an advertisement that is then regulated by the rules. Yeah. Well, there's a lot of people. And what I will say to you is, I don't know the answer to that question. And I think it's a case-by-case basis. And the only thing that I can say is you need to be aware that, how the Supreme Court has handled those things. And because it could be deemed an advertisement.
What about this Facebook page that alumni here has, this SVLC alumni Facebook page? I see a lot of lawyers, they'll get on there and they'll say, does anybody know how to do such? Does anybody know?
Don't quote me on this, but I think there's a rule that deals with that deals with alumni and exchanging information. Yeah, that's different. Yeah, that's a little different.
I like that site.
Yeah.
Right.
I do know what you're talking about. But all of that is regulated, and we can only assume that they've gotten all that cleared. He could be. That's why I said that. The duty to supervision is particularly important in regards to non-lawyers, that they don't unintentionally stray into the unauthorized practice of law. That is kind of what I talked about in the beginning, that, if we're being honest, our support staffs are really running our offices. When I say running our office, they're not practicing law, but they're really running our offices and operating in a remote environment where we may or may not be there every day. You want to be very, very careful that it doesn't appear that the support staff is actually lawyering, right? Because that's when they cross the line. And so that supervision responsibility, as I said, might be little bit more difficult right now. Some tools that can help you connect with your client and your staff, make sure that you are meeting your professional obligations to supervise lawyers and the non-lawyers in your organization. And wait, hold on, Reed. Reed gonna make me go back. Here we go. It's 5.3B. I'm sorry, I didn't hear you. And so this, I copied and pasted this from the Supreme Court website. Chief Justice Weimer always says this when he talked about the difference and knowing the difference between your professionalism and your legal ethics. And professionalism concerns the knowledge and skills of the law faithfully employed by a lawyer. Your legal ethics is a term used to describe a code of conduct governing proper professional behavior, which establishes the nature of your obligation owed to the individuals and your society and the client alike. Legal ethics set forth the standards of conduct required of an attorney. Professionalism includes what is more broadly expected. And I just cited the rules from the Louisiana Supreme Court. So I like to put that up there and I call it the standard and the difference. And you know, as the Chief Justice would say, we should always be cognizant and aware of the difference that our legal obligations are, you know, those things that are tied to our professional conduct as an attorney. That too. And so I just, this is the LSBA page. This is completely copied off of their page. This is where I got a lot of my research from. The ABA has some resources. This is all the webinars that have been conducted over the last 20 months. I will tell you there's one on there that's of particular interest about all of these electronic databases and these software things that we use in our office that that you might want to check out and just see. They talk about the security features and the risk of breaches and what the products are. It's very detailed, and some technocrat attorneys, cybersecurity attorneys, talking about some of the various platforms that we use to conduct business. All of the court's orders are on a special page on the Supreme Court, and I just listed some, you know, bigger jurisdictions of all the COVID orders that they have out there. So if you find yourself in an ethical dilemma, this is a shameless plug for my ethics advisory committee. If you find yourself in an ethical quagmire, Louisiana LSBA has a confidential, non-binding ethical service where you can ask a direct question and you can get an informal opinion, a private opinion from the ethics counsel. You know, so most people don't know that, but it is there. It is private. It's, you know, and some of them are noteworthy, and they are released to the public. But I mean, obviously, they don't say you requested it. But sometimes there's a novice question that is answered. But that is a service that they have free of charge, and that you can, you know, and Eric Bearfield is the ethics counsel for the state of Louisiana State Bar. And if everybody want to reach out to me anytime, you know, that's my contact information, who I am and where I sit currently. I will tell you the phone don't ring to me. They don't let me answer the phone. But, you know, just tell them that you want to talk to me, but it'll get to me. But, you know, but I am pleased to say that is the end of my production. If anybody has any questions, comments, or concerns, yeah, I will send a PowerPoint. Hey, Mr. Russell. James Russell is from New Iberia. Huh? Hey, my sister Vanessa. If anybody have any questions, it is always fun to come to these things, and it's like a reunion to see everybody, but see everybody virtually. And well, I was just about to say that hopefully next year we can all get back together in person. Yeah. And then he called me on my cell phone like at 5:30 in the afternoon. I remember it. I was just waiting for you to remember it. So he's talking about he is talking about my former life as Southern's Deputy General Counsel, my former life. You wouldn't imagine how many calls we get that people just yelling and screaming at us. I'm from Donaldsonville. Yeah. So everybody online, I am going to sign off the 40 people that's online. Thank you guys for participating, and happy holidays to everybody. And I hope that I could run into some of you guys at holiday parties or like. But I will say what our chancellor say, our chancellor always sign off and say, stay safe and stay healthy.